Once I go on mute, feel free to start. Okay? Okay, the floor is yours.
Um, Hello, good evening, everyone. Can I be heard lang?
Yes.
Okay. So, Gerald and I will be talking about ethical, legal, and moral constraints on information systems. So, learning outcomes, you'll be able to analyze decisions and courses of action from professional, ethical, and moral perspectives, select appropriate and legal courses of action in keeping with professional codes of conduct, and understanding and responding to issues of concern such as personal privacy. So, the terms ethics and expectations, the terms ethics, morality, and professionalism are often used to describe our expectations of managers and employees. So, professionalism can be described as acting to meet the standards set by a profession in terms of individual conduct, competence, and integrity. Ethics describes beliefs concerning right and wrong that can be used by individuals to guide their behavior. Morality is concerned with an individual's personal beliefs of what is right and wrong. So, morals define personal character, while ethics stress a social system in which those morals are applied. So, in other words, ethics point to standards or codes of behavior expected by a group to which the individual belongs to, like professional ethics, while a person's moral code is usually unchanging. The ethics of the person can be other dependent. So the IS professional is in a difficult position when undertaking their work since there are a number of constraints affecting their behavior. So constraints and potential areas of conflict related to duties and responsibilities of the IS professional are profession and code of conduct, society and public safety, state and legislation, and personal values. So for codes of conduct, members of professional associations are expected to abide by a set of principles that set out minimum standards of competence, conduct, and behavior. In addition, personal beliefs concerning right and wrong, professionals must also ensure that they obey the law and meet the standards set by their professional association. So for in information systems, relevant code of ethics have been developed by many professional associations. These codes vary in their complexity and degree of bindingness. So these are the some of the associations that are available now. So the ACM, ACS, the BCS, CIPS, CSSA, the HKCS, IEEE, and the SCS. So, the ACS, for example, comments an essential characteristics of a profession is the need for its members to abide by a code of ethics. The society requires its members to subscribe to a set of values and ideals which uphold and advance the honor, dignity, and effectiveness of the profession of information technology. So, one of the most comprehensive professional codes have been developed by the British Computer Science, having separate codes of conduct and practice as well as professional development. So the code of conduct is split into four areas covering a member's duties with respect to public interest, employers and clients, the profession, and professional competence and integrity. So this is the code of conduct for the British Computer Society. So one example is for the public interest. So one of their it's like in your professional role you shall have regard for the public health, safety and environment. This is a general responsibility which may be governed by legislation, convention or protocol. If in doubt over the appropriate course of action to take in particular circumstances, you should seek the counsel of a peer or colleague. You shall have regard to the legitimate rights of third parties. The term third party includes professional colleagues or possibly competitors or members of the public who might be affected by an IT system without their being directly aware of its existence. So, for duty to relevant authority, you shall carry out work or study with due care and diligence in accordance with the relevant authority's requirements and the interests of system users. If your professional judgment is overruled, you shall indicate the likely risk and consequences. The crux of the issue here, familiar to all professionals in whatever field, is the potential conflict between full and committed compliance with the relevant authority wishes and the independent and considered exercise of your judgment. If your judgment is overruled, you're encouraged to seek advice and guidance from a peer or colleague on how to best to respond. So for duty to profession, you shall uphold the reputation and good standing of the British Computer Society in particular, and the profession in general, and shall seek to improve professional standards through participation in their development, use, and enforcement. So, as a member of the BCS, you should also have a wider responsibility to promote public understanding of IT, its benefits and pitfalls, and whenever practical, to counter misinformation that brings or could bring the profession into disrepute. For professional competence and integrity, you shall seek to upgrade your professional knowledge and skill and shall maintain awareness of technological developments, procedures, and standards which are relevant to your field and encourage your subordinates to do likewise. For professional responsibilities, another way in which the responsibilities of managers, developers, and users can be described is by considering some of their obligations to their employees and employers, the public, the state. So for employers and employees, both managers and employees are expected to balance a number of duties and responsibilities in the course of their activities. These can be divided into two broad areas: the responsibilities of all staff to the employer and the responsibilities of managers to the staff they supervise. So first, the employees should look for ways in which they can help the company to achieve its aims. The second, all staff should take responsibility for their actions and the quality of their work. Thirdly, managers should assign tasks to employees based on skills and experience. And for the fourth, managers should ensure that their staff are adequately trained and should assign responsibilities carefully and fairly. For the public, two of the most important obligations placed upon professionals concern the duty to protect confidential information and the duty towards public safety. So first is the duty to protect sensitive or confidential information is normally described in terms of developing security measures to prevent hackers and other unauthorized users from gaining access to company data. So however, in terms of a duty to the public, this responsibility can be extended to encompass areas relevant to civil liberties, such as censorship, the right of individuals to view personal data held on them, and the privacy of email messages and other communications. So, safety critical system, it is where human lives rely on the correct operation of a computer based information system. This is normally referred to as a critical system. For the state attempts to maintain standards and behavior by enacting legislations to regulate the behavior of companies and employees. So, although specific pieces of legislation, such as the Computer Misuse Act 1990, are aimed directly at those working in the field of computer based information systems, companies and employees must also observe more general laws. So, as an example, the Health and Safety at Work Act 1974 means that all employees are responsible for safety in the workplace. Staff are required to take immediate action in response to any hazard or danger to the health. For social issues, information society is a term that has been coined to describe a modern population that is conversant with and reliant upon information and communications technology. So, some of our social issues are employment, scaling versus the the digital divide, personal privacy, and crime. So for the first one, employment. At present, the demand for skilled IS professionals far outstrips supply, leading to what has been termed a skills shortage. So, a skills shortage describes the significant shortage of educated and highly skilled IT practitioners entering the IT industry. So, skilling versus the skilling. So, are employees being given the opportunity to develop new skills in depth, or are they developing a broader range of skills but failing to develop any real expertise in one or more specific areas? So, for example, the seagoing engineers are no longer expected to possess high caliber diagnostic skills. So, as they can now rely on automation. So, at best, they only need to be able to quickly assimilate information provided by the systems. So, the engineering and brainwork involved in the design and construction of digital technologies facilitates task simplification and standardization of work processes to the extent that less skilled workers with minimum training are able to perform the same jobs earlier assigned to highly skilled workers. There is thus actually the skilling of highly skilled jobs which previously demanded educated workers and where work processes were difficult to capture because of the unpredictable and uncertain nature of work. So the upskilling thesis suggests that the knowledge and skills of workers is a dominant source of productivity. It is argued that as work processes are fragmented into simplified tasks, the machines take over the repetitive work and while the workers should move towards furthering innovation. So as the technological systems increase in complexity, the gap between the human operator and the technical system tends to increase as well. The transformation of technologies places new demands on human operators at work who must control, diagnose, and solve new kinds of situations. For the digital divide, concern is growing that society may eventually become divided into two distinct groups. So, one group will be made up of those who have access to technology and are able to obtain information via the internet. The other will be made up of those who are unable to gain access to technology and information. For personal privacy, so surveillance society, this describes a society where the actions of individuals are closely monitored by government, departments, and major companies, and where these organizations routinely gather and process large amounts of personal information. For data valence monitors or checks people's activities or communications in automated ways using information technologies. So another way that personal privacy is being is profiling. So in their work, they found that they were able to predict the IQ, personality, ethnicity, sexuality, and political beliefs of individuals by examining their likes. So what is also computer monitoring. So the use of computer and communication technology to monitor the activities of individuals. So, Akelon is a global surveillance system that monitors communications around the world. The project is operated by the USA, the UK, Canada, Australia, and New Zealand. So each day, millions of telephone calls, faxes, and email messages are intercepted and scanned for keywords and phrases. So these are some of the crimes. So computer criminals that they make use of technology to perform a variety of criminal acts ranging from vandalism and sabotage to hacking and fraud. So information warrior seeks to obtain data by any means necessary. Such people may resort to illegal methods such as hacking in order to obtain the information they require. So the hacker, individuals who seek to break into systems as a test of their abilities. Few hackers attempt to cause damage to the systems they access, and few are interested in gaining any sort of financial profit. So these are the types of computer crime. So theft involves altering computer records to disguise the theft of money. The theft of services can include a variety of acts such as the unauthorized use of a company's information systems. Software theft, also known as software piracy, involves making unauthorized copies of software applications. Data theft can involve stealing sensitive information or making unauthorized changes to computer records. So that is all for my slides.
Okay, hello. Can you hear me?
Yes.
Yep.
Yes.
Okay. Thank you. Okay, so before I proceed, do you have any questions with regards to the presentation of Christina? Okay, so I think there's none. So I hope you can see my slides right now.
Yep.
Okay, thank you. All right, so now we go to the next topic, which is about the legal issues. So our reference book, which is the Business Information System, the fifth edition, and it was published in 2015. And from 2015 up to the present, there were new legislations or updates, especially on the GDPR, which was enforced on May 2018 or April, May 2018. So I will try to discuss it here, but mostly the legislation that will be presented are focused on the UK's legislation, but other countries have, similar laws and guidelines that deal with the same issues. Okay, so the first one is about the UK's Data Protection Act of 1998. So it is the UK's implementation of the EU's GDPR legislation. Uh, so it has the following general principles. Information shall be obtained and processed fairly and lawfully. Information shall be held only for one or more specific and lawful purposes. Companies should not hold information that is excessive or not relevant to the purposes the company has registered under the Act. Information held on individuals should be accurate and up to date. Information should not be held for longer than needed. Individuals have the right to see the data held on them and have corrections made when necessary. Companies must take measures to protect information from unauthorized access. So it's very straightforward, and I know all of us are very familiar on this one because this very familiar, they're very similar to the GDPR. And even if we have a comprehensive EU GDPR, there is still a local GDPR implemented in the UK because there are some scenarios or some topics or sections of this act is very specific to the state or the country of UK. So like, for example, there is a section under this act which is particular to the immigrants. So that topic is not part of the comprehensive GDPR that we used to know. So if your company is dealing with a country, a country that has a local GDPR, so make sure that you know about it and understand and check what is the very specific requirements that they put in that legislation. Because if you're already implementing the GDPR, there will be less work that you will have to follow because most likely they also follow the guidelines under the GDPR, but there will be just some specific uh, topics that they will be incorporated based from their situation in their country. So yeah. So another thing is the safe harbor. So this was replaced by the privacy shield. So this allowed to transfer of data from EU to US. But again, it was invalidated in July 16, 2020 by the Court of Justice of the European Union. So the following are the principles of this safe harbor or the privacy shield. First one is the notice. So people must be told that their data is being collected and how it will be used. And the second principle should be choice. People must be able to opt out of the collection and transfer of data to a third party. The third one is the onward transfer, which refers to the data may only be transferred to a third party if they allow or if they follow adequate data protection principles or measures. Another thing is the security principle, which has a reasonable security precaution must be taken to protect information from any loss or unauthorized access. And the next one is data integrity, which pertains to the data must be relevant, accurate, up to date, and appropriate to the purpose that it has collected for. The The next one is the access. So this one pertains to the people must be able to access information about them. And if there's a need to correct or amend or delete the information, they should have the access as well on that. And the last one is the enforcement. So there must be an effective mechanism to enforce these principles that we have discussed. Okay, so this is the Computer Misuse Act, or the CMA 1990. So this pertains to it's the UK legislation that criminalizes the act of accessing or modifying data stored on a computer system without appropriate consent or permissions. So the following are the guidelines. So unauthorized access to a computer material. So this refers to the hacking. The second one is unauthorized access with the intention of carrying out or assisting others with the commission of further offenses. So this item refers to entering a computer system to either steal data or destroy a device or a network, such as when you plant a virus in a certain network or device. Okay, the next one is unauthorized modification of computer materials. So this refers to modification or deleting data, and also it covers inserting of malwares or spywares onto the computers. And the last two are the impairing the operations of a program or reliability of the data, and preventing or hindering access to any program or data. Okay, the next legislation pertains to the Privacy and Electronic Communications Regulations of 2003. So this EC directive sits alongside the Data Protection Act and the GDPR. So they give people specific privacy rights in relation to electronic communication. So if you are a company who is communicating with the UK citizens, so you should follow specific rules on marketing calls, emails, text, and faxes. At the same time, on the cookies and other similar technologies, keeping communications services secure, and customer privacy as regards traffic and location data, itemized billing, line identification, and directory listing. Okay, so the Copyright Designs and Patent Act of 1988, this gives creators of digital media the rights to control how their work is used and distributed. So this legislation can be used to provide organization and software developers with protection against unauthorized copying and design software, printed materials, and other works. So this covers music, book, video games, videos, softwares can all be under this law. So anything which you design or code is automatically copyrighted and may not be copied without your permission as the digital creator. So when you buy software, for example, copyright law forbids you from giving a copy to another person or to your friend, or making a copy and then you sell it. Another thing, it prohibits you for using the software on a network unless the license you sign allows it. For example, you may be allowed to install an application on 3 devices within a family. At the same time, it prohibits you for renting the software without the permission of the copyright holder. And of course, some applications or programs you will only run if it will only run if there's a specific hardware plugged to that computer, or maybe you have a unique code to enter for that specific device only. So those are the things that can be done or prohibited. Okay, so let's just discuss the terms here. So the copyright, this is pertaining to the legal right of the owner of intellectual property. So in simpler terms, copyright is the right to copy. So this means that original creator of the product, and anyone they give authorization to are the only ones with exclusive right to reproduce the product or the work. The next one is the patent. So the patent provides its owner with a monopoly, allowing them to exploit their invention without competition. So basically, the protection offered by a patent lasts for a number of years, but does not begin until the patent has been granted. So so this allow also the creator to gain some revenue based from the investment that he have put to that product. Another one is the cross-licensing agreement. So this agreement allows companies to share patents so that each can produce and market a wider range of products. So one of the example here would be Google and Samsung. So they have an agreement, cross-licensing agreement, which between the Android and the smartphones of Samsung. Another example would be like the Google and the SAP. They have this long-term patent agreement, which includes a large selection of products and various software patents as well. And I guess the Apple and Microsoft as well, they also have this kind of agreement. So these two companies have a cross-licensing agreement since 90s. So which covers the technical software and at the same time the design patents. Okay, so now we talk about the reverse engineering. So it is the attempt to recreate the design of software or hardware by analyzing the final product. Reverse engineering is a precise form of product teardown that can be the basis of many intellectual property cases. So the process can be applied to products. It can also be applied to systems or components from mechanical parts or assemblies. It can also be applied to a biological. You can also do reverse engineering from a chemical or organic matter. So in intellectual property, the legality of the reverse engineering process is a frequently debated subject. So, but they should have a non-disclosure agreements and user license agreement and the anti-circumvention, which can act as a legal barrier to any reverse engineering. So when it comes to registered design, it can be thought of as a similar to patents, except that they only deal with the appearance of the given item. So it's more on the physical appearance of the item or the product. So as an example of this is Apple. So Apple has many registered designs. So in 2019, alone, Apple has filed to protect 458 designs in Europe. So that includes the design in watches, their tablets, their computers, the interfaces, the adapters, cases, and others. So while the trademarks, this one distinguishes a company's product or services from those of its competitors. So often we see this as a logo of the company or the name of the company itself, or maybe a phrase or a slogan or a statement that is very particular to the brand or to the company. Okay, so the next one is about the Regulation of Investigatory Powers Act 2000. So the Act introduced measures to allow electronic communications to be monitored by government agencies. This is important to note that this act does not just cover surveillance by police, but also other law enforcement bodies such as the intelligence services of the UK, as well as the other public agencies of the UK, so including the local government of the UK. So in some circumstances, companies can be obliged to comply with requests to supply information considered confidential. So now we go to the Waste Electrical and Electrical Equipment Directive. So it deals with the safe and environmentally responsible disposal of electrical equipment, including computers and other common office technology. Basically, it's a combination of materials and components because, as we all know, these are hazardous. It has an hazardous content, and if not properly managed, it can cause major environmental or maybe health problems. So basically, the purpose of this directive is to improve the collection, the treatment, and the recycling of the electronic products. And of course, there's still a lot of legislation which we might not be able to discuss it further, but I'll just run through it. So the first one is the Human Rights Act of 1998. So this one pertains to the fundamental rights of any citizen, including their right to privacy. The next one is the Privacy of Information Act of 2000. So this pertains to the right to request any information held by a public authority. The Police Act of 1997. So it gives the police and other agencies the power to monitor the communications. The next one is the Official Secrets Act 1989. So this prevents individuals from disclosing any information related to the national security. The next one is Obscene Publication Act 1959 and the Protection of Children Act 1978. So these legislations would deal with issues related to the copying of pornographic materials from the internet. The next one is the Malicious Communication Act of 1988. So it makes an offense to send any message that might be considered obscene or threatening. So this covers that act. The next one is the Defamation Act of 1996. This concern about the slander and libel. So as we all know, we have cyber libel as well here. So this legislation extends to comments made in email messages or maybe in social media or other materials on the website or any website. The next one is the Electronic Communications Act of 2000. So this act serves to make electronic signatures legally binding. And the last one is the Anti-Terrorism, Crime, and Security Act of 2001. So the information system industry or the IT industry has the requirement to make sure that certain companies retain data on consumers' internet and telephone activities. So for example, that all of the activities, all of the internet activities of a certain user or user can be retrieved or searchable whenever it's needed. Okay, so we're done with the legal issues. We go now to the software piracy. So the software piracy is the act of stealing software that is legally protected. So it's a major issue, affecting many companies and developers today. So consequently, companies need to implement their anti-piracy protection systems on their softwares. So there are many ways to, protect your software. Most companies make sure their software is protected legally by having a user agreement or the end user license agreement. It allows the software developer to provide information to the consumers that unauthorized copies is against the law and helps prevent people from unknowingly breaking piracy laws. Another measures could be the company can have a product key in their software. So this one using a unique combination of letters and numbers to differentiate the copies of the software. Or they can also have like a built-in protocol to shut down or stop the working of a software if the source code is modified. So yeah, this kind of tamper-proofing prevents people from pirating the software through the manipulation of the code. And yeah, probably you also noticed this one, the watermarking. So you will see in some software some company logos, which provides information that it's legally copy. It's a legal copy and it's a legitimate copy. Okay, so let's just check the perspectives of different stakeholders in terms of the software piracy. So for the end user side, these software packages can be acquired at a very low cost. That's why most of us, of course, we want everything for free, and but at the same time, we have also to consider the piracy law and other copyrights and patents. So, but of course, on the end user side, they're just focused on the low cost. So as long as it's free and they can install it easily on their laptops, it's easy for them to just install it. Another thing is that some users will collect software applications in order to trade with others or create a library of applications. At the same time, many users consider software piracy a trivial offense. So a lot of the users will not or will ignore this kind of these laws or legislations because they think it's just an ordinary offense and there will be no penalties, or there will be no heavy penalties that they will have once if they have a software piracy. And the user usually seen as a business, I mean the software piracy seen as a business venture and used as a source of revenue. So maraming businesses na kumikita in terms of the software piracy. Okay, another stakeholders will be the software developer or the software company. So copying software, it is argued that reduces the revenues generated from the sale of the software and jeopardizes new development. So this prevents the company to make improvements on their software because the revenue that they were expecting will not reach. So software companies face a need to safeguard the profit margins and recover development costs as quickly as possible. So because of that, the result will be the prices must be increased so that the losses made due to illegal copying can be recovered. So in short, those legal users will be the one who will cover all the losses that they encountered. And the last stakeholder will be the business organizations. So of course, they are tempted to, especially the startup or the small company, small organization, they are tempted to make additional copies of a given software packages, and it will result in numerous repercussions. And one of those will be they can suffer from severe financial penalties and negative publicity. And also, if an employee accused of using illegal software in the course of their duties, the employees might take legal action against the employer. And also it affects the profitability if they deprive of the application software needed to support the day-to-day activity, especially if that software is very important in the business. So if that is an unlicensed, then you will have a problem in terms of the profitability if you will install unlicensed softwares. Okay, so there's an organization called BSA. So it terms for the Business Software Alliance. It's an organization formed to act against software piracy. So the recent publication of their survey was 2018. So based from their key findings, they identified four key findings based from this recent survey that they conducted in 2018. So the first one is the use of unlicensed software, while down slightly, is still widespread. So unlicensed software is still used around the world, so at an alarming rate. So if you will check the actual survey, you will see like 60 to 90%. Usually most of the personal computers have unlicensed softwares. And they also found out that the chief information officers report unlicensed software is increasingly risky and expensive. That's because the malware from those unlicensed software cost companies worldwide to like $1 billion that they will have to cost because of that malware. And the CIOs reports that avoiding data hacks and other security threats from malware is their number one reason for ensuring their networks are fully licensed. Another thing is that improving software compliance is now an economic enabler in addition to a security imperative. So when a company takes steps to enhance their software management, they can increase the profits by as much as 11% based from this study. And the last one is that the organization can take meaningful steps today to improve software management. So there's a study that shows that organizations can achieve as much as 30% savings in annual software costs by implementing a robust software asset management and software license optimization program. So basically, the software asset management has the goal to reduce the IT cost and limit the risk, the legal risk, the business risk related to the ownership of or the use of the software. Yeah, so that's the last one. I'll just give you some of the resources that I was able to get from the internet. So one thing is this one, the United Nations Conference on Trade and Development. So in their website, they have a summary of adoption of the e-commerce legislation worldwide. So I include this one because aside from the e-commerce, it also pertains to other laws, such as the electronic transaction laws, data protection laws, cybercrime laws, consumer protection laws. So if I go to their website right now, okay, let me just share. Okay, wait a minute. Okay, can you see the website? Okay, so this is the website of the UNCTAD. So basically, it will give you an overview of how many countries have a legislation and how many countries have draft legislation and how many countries have no legislation and how many countries with no data. So you can trim it down to different topics. Like for example, if you focus on the electronic transaction law. So if you click this button, it will refresh the screen and the numbers will also change and you can select the country that you are interested. And the good thing about here is that you can also download the full data. Like for example, I selected the electronic transaction law. So if I click this download full data, I can download in an Excel format the uh, the content of all of the countries. Okay, so I guess you cannot see it, but it's in an Excel file where you can see all the countries as well as the title of the legislation and also the links. But if you don't want to download it, you can also open it online. So if you select one country, for example, like Philippines, you will see over here, we have a legislation for electronic transactions, consumer protection, privacy and data protection, and cybercrime. And if I click this plus icon, it will open the details of the Philippine laws. So we have here the electronic transaction law. So it has a link here. So you may link this one and it will open the website of the law field project. And it will open the content of the actual legislation. Okay, so you can also check the other laws, the consumer protection law, in which in Philippines, we have the Electronic Commerce Act or the E-Commerce Act of 2000. In terms of the data protection and privacy law, we have the Data Privacy Act of 2012. Everyone knows it. The cybercrime law, of course, the Cybercrime Prevention Act of 2012. Okay, so that's the website of the UNCTAD. Another thing is the website of okay, let me just refresh. This is the website of the World Intellectual Property Organization. So they have a lot of resources here. They have a database as well if in case that you would like to search for the different brands. So you may search it here, as well as the registered designs here. What else? You may also check the different IP laws for different countries. So they have a database as well for that. Okay, so I think that's all. If you have any questions, so feel free to raise it now.
Okay, thank you for that, Gerard and Christina. Any other questions from the class?